SJC-11980, Commonwealth v. Jamil J. Campbell.
Good morning, Ms. Sexy. You may proceed.
Good morning, and may it please the court, Hella Saxe on behalf of the Commonwealth. In this case, the court should decide whether an officer who lawfully stops a car and is given a rental agreement that does not bear the driver's name and says no other drivers permitted has probable cause to believe that the driver is using the car without authority. And we submit that the answer to this question should be yes. In the present case, the trooper lawfully stopped the defendant for failing to obey a stop sign and was given a enterprise rental car agreement that was bearing a female name. The male defendant was the only occupant of the car. And the agreement further indicated no other drivers permitted, as available in Record Appendix page 33 of our brief. And at that moment, the trooper made the decision that, or he had probable cause to believe the defendant was not authorized to further drive this car, and made the reason.
Was there a conversation with the mother who was the on the rental agreement?
The trooper testified that he, at some point in time, he believes it was after the decision to impound had been made. He, at some point, spoke with her. He had no specific recollection. The defendant testified, on the other hand, that he was calling his mother and that she was on the phone while the trooper was standing at the car. We have no fact findings from Judge Johnson in this case, so it's really not.
I have a question about the focus so much on lack of authority, which seems to me to be really focusing on what the rental company's concern might be about. But when I looked at the statute, and just to ask your question about what do you make of this point, of this provision in Chapter 9032E.5 that seems to recognize that there is such a category of drivers who are, with the renter's permission or accession, are driving. So I mean, so if there is that category, which, you know, I guess it depends on how much losses they're liable for, but that's wholly different from this. If there can be, and the statute acknowledges such a category, why doesn't he fit within it? Why isn't that the concern of people stopping? Not liability, but whether this person is driving with the renter's permission or accession.
Well, first of all, the question of the statute at issue here is never liability. The statute protects the owner of a car, and whether that be a rental company or a private
right, but that's what I'm
owner.
saying. This statute, which protects renters, owners of rental cars, acknowledges the existence of those who drive with a renter's permission or accession. So if that's acknowledged, there's a category. Your construct is there's only one owner, and that's the rental company.
Well, that is correct. There's only one owner, and the rental agreement says that. And the agreement at issue here further indicates no other drivers permitted.
According to the rental company, but only according to the rental company.
Well, the rental company is the
Well,
owner.
it's just that we're going to give, you're basically saying that the government has to acknowledge the ownership rights as being primary?
Absolutely.
I don't see why.
Because the Massachusetts use without authority statute does protect the ownership rights. This is not about contracts. It's not about insurance liability. It is about the ownership right. It is simply essentially a car version of the right to
But doesn't
exclude
one of our
others from-
cases refer to it as related to the larceny statute?
That is correct. It is a lesser included offense of larceny of a motor vehicle.
Are you relying on Chapter 90, Section 32E.5 for purposes of deciding who the authorized driver is?
That statute is very limited in its applicability, only limited to, I believe, the next Chapter 32E and 3/4. It is simply instructive in reading that there is the rental company is able to decide who the authorized driver is and is able to put that on the rental agreement. There's no question that Pamela Gillard, who was listed here, who rented the car, was authorized. There are also options to add additional drivers, but where the rental agreement says no other drivers permitted, and the trooper is confronted with that in the context of a lawful motor vehicle stop.
But isn't the rental agreement really designed to answer the questions that are addressed in Chapter 90, Section 32E1/2, which is an insurance issue?
No, it is not. It is also at the point in time when it is handed over here, as it was here, as a substitute for the registration of a private motor vehicle.
But if I have a car that's registered in my name alone, I can let my wife or my child use my car.
Absolutely. But if you put on your registration either a comment, no other drivers permitted, or no one under the age of 30 permitted to drive my car, then that would have the same effect.
No, it has a consequence of insurance coverage.
No, it would also be you have as the owner, the ability to protect your property interest,
But
your
it's a
ownership
different-
interest.
Isn't there a difference between my ability as the owner to protect my property interest and saying that the government has to enforce it? I mean, becomes my agent?
Well, is this
And find somebody criminally liable because there's a violation of my wishes there? Or in this case, there is potentially a violation of the contract?
Your Honor, if you posted a no trespassing sign on your property, you would also expect the police to enforce your ownership interest. And here it is the same in the context of a car. And this court, in its decision, has very clearly indicated that this is a lesser included offense of larceny of a motor
Well, let me
vehicle.
go back to that. If an owner of an apartment building posts a no trespassing sign, but all the people who live in this 20-unit building have guests, who defines the trespasser? The renter with invited guests?
Your Honor, there's
Or the owner?
the case law distinguishes between the owner's ability to control the common hallways from trespassers. The owner cannot control who someone can invite into their apartment. But as I think instructive is the case of Commonwealth versus Hood, 389 Mass 581, in which it concerned a commercial property of the Draper Labs.
Yeah.
And the court said that an employee of that company could not give a license to trespassers to come onto the property in order to distribute pamphlets. And the same is the same case here. The owner is able to control who can use the car. And in this case, the trooper is not constitutionally required to then investigate whether he can apply the towing policy in a reasonable manner. He is not under Henley and this court also.
Let me be clear as to that. I gather, am I correct that if you are wrong, that indeed the arrest was not appropriate for use without authority, then the impoundment and the inventory was also illegal?
No, Your Honor. Under for use without authority, it is within the trooper's discretion whether to summons an individual or whether to arrest.
No, I'm saying if it's not a crime. If indeed we were to determine that it is not a crime to be driving a car with the renter's permission but not the owner's permission, then do you agree that the subsequent impoundment and inventory search was illegal?
Your Honor, in this case, the facts are absolutely lacking to assume that the renter's permission was given here. So if the court...
Wait, the facts are lacking to assume that the renter's permission was given?
Yes, because Judge John...
Evidence of on the phone, right?
No, Judge Johnson did engage in very limited fact-finding here, and the facts that he found indicate that he credited the trooper and he discredited the defendant.
He credited the trooper with respect to the stop. I agree with you completely on that. I
Yes.
don't know that you can take it any farther than that.
But neither can my sister, and in saying that now that means that Judge Johnson credited the defendant's testimony as to any permission that was given to the
but-
driver. We simply
but-
do not have.
Right, but if an unauthorized driver, at least an unauthorized driver with respect to the rental agreement, is driving the car, and I think this is Chief Justice Gantz's question, and we were to determine that that is not use without authority within the meaning of the crime as defined in the statute or common law, then is the impoundment, it's not a crime, okay? It may be a violation of the agreement. Is the impoundment still proper?
Under this, if the trooper were now in a situation where none of the points of the impoundment procedure were applicable, then yeah, at some point he would not be able to impound the car. However, those are not the facts of this case, and that is not what the case law in Massachusetts indicate.
Well,
where
two things. I'm curious. Your argument really is that there was probable cause to arrest for use without authority. Now, that is a different question from whether there might be an affirmative defense to it. That is, the person who had authority lent it to me, right?
I would argue that is not an affirmative defense because
How could that not be an affirmative defense? If the renter says, I gave this person permission to use the car that I rented, maybe a violation of the rental agreement, but how is that use
it is
without authority?
simply not the mother's permission to give in this case. And in Lawson, the appeals court has indicated so much. They said only the rental company can authorize a person to drive the car, and where that authorization is not given by the rental company, it is simply lacking.
Anytime a renter allows their child, their spouse, to drive to the grocery store, that spouse has committed a crime. A crime because they're not on the rental agreement. Is that right? Is that your
That is-
argument?
Yes and no. I think there might be different regulations that a spouse on a rental agreement may always
Aren't.
be.
Let's assume
Well,
that.
in that case, then yes.
And then the husband would also be liable for aiding and abetting the commission of that crime by saying, yes, you may take it.
Potentially. However, the husband also then signed the rental contract, and in this case, we are operating with a rental contract that says explicitly no other drive is permitted. It does not say spouse is permitted or names
I mean,
additional.
usually you got to pay $10 a day or something to get anybody else, including the spouse, on the rental agreement.
That is correct.
So if you don't pay, if you $10 a day, and in Justice Cordy's example, person said, I want to pop by the supermarket to get something, then the spouse says, okay, why don't you use the rental car? Both have committed a crime of use without authority.
That is indeed the law in Massachusetts, yes.
And if, let's imagine it's a personal car, let's keep Justice Cordy's family involved, and Justice Cordy's has said to his son, I really don't want you driving my car, and the son is stopped, and they see that the car is owned by Justice Cordy. Police officer then can arrest for use of that authority because the name on it is Justice Cordy and not the son?
As I would say, under those circumstances where the registration is in Justice Cordy's name but is otherwise silent, I think an officer would be expected to inquire of the owner whether he or she has given.
Okay, so let's say he calls up Justice Cordy, and Justice
Can we get
Cordy
me
says-
out of this?
Okay, he calls up me, and he says, your son is driving this car, and I say, No, not again. I told him he couldn't do that. He can't do that. And I hang up the phone. He can now, my son has now committed the crime of use without authority?
There would be probable cause to either, yes. So in the officer's discretion, it is not necessary to arrest, but the crime would have been established, yes.
Okay.
All right, thank you.
Thank you, Your Honor.
Good morning, barely, Ms. Jacobstein.
Good morning, Your Honor. Rebecca Jacobstein for Jamil Campbell. With me today is trial counsel Adithi Goel. This is actually not about ownership rights. That's not what Youth Without Authority is protecting. It's protecting interference with ownership rights. And at the time of this, the offense, alleged offense, this when is the person with the ownership rights is the renter. And use without authority is the use of a motor vehicle without the permission of the owner.
Well, what do you say about the appeals court case? I think it's Lawson. It says that only the rental company can authorize someone to drive.
Well, I say two things. I say one, that is dicta, and two, that is wrong. No place else.
But is it the law of Massachusetts?
No, that's not what the unauthorized use with the use without authority statute stands for. It stands for you're criminally liable if you use a car without the permission of the owner or a person who exercises the rights of the owner. If I have a car, I can let my husband use the car. And if then my husband lets his friend use the car, he can do that too, because when I let my husband use the car, he can confer that right to somebody else.
But is there probable cause to believe where the individual is not on the rental agreement and the rental agreement says this other person is the only authorized driver? Is that probable cause to believe that there's a violation of the law?
No.
Hence could be, well, I had permission from the owner, the renter.
There are Massachusetts cases addressing when you can think someone has stolen a car or not. And actually, in the rental car scenario, there's Commonwealth versus Bartlett, which I can send in a 16L letter because I did not mention it in my brief. But in that case, the man was driving a car, and the police officer pulled him over, and for a variety of reasons suspected that he was a drug dealer because he was driving a rental car, and other reasons besides that. And the appeals court said no, people can drive cars for rental cars for a variety of reasons. But what they say is there was no indicia that this car was stolen. So, he had a valid license, he had a valid registration, he didn't make any furtive gestures, he pulled over immediately, he was cooperative, he was respectful. All things that happened in this case. But if there was a reason to believe that this use was unauthorized, the police officer can extend the stop and then make a phone call and check with dispatch and see if it's been reported stolen.
So what's the,
Required to?
To see if it's reported stolen.
Well, in other words, if there's, I guess it really goes to the probable cause question. Is the police officer required to make that phone call to check?
To dispatch or to the owner?
To the owner?
Or to the renter?
Or to the
owner?
renter?
Oh,
To the renter. Yeah, to the renter.
I think that Judge Johnson was correct. I think that you cannot presume that somebody has stolen a car just because their name is not on the registration or because they're not on the rental agreement. I don't think we can just have a presumption that a car is stolen or being used without authority because your name's not there. If there are additional reasons, then you can inquire. But you can't presume. I think that the officer can't call the renter to inquire and hold the person there unless they have an actual reason to think that this car was unauthorized. And there may be a variety of reasons they think that, but then they should have to make the phone call.
So if I see your car with a key in the ignition and I say, gee, I got to get someplace fast, and I get into your car and I drive it to where I have to go and I'm going fast and the trooper stops me and I say, well, I'm using Rebecca Jacobstein's car, and he can't presume that I'm using your car unlawfully, and you're going to have a livid fit if he lets me continue driving your car.
if he can't offer who I am, and he doesn't know me, but let's say he's my neighbor. Let's say she's like, oh, here's my license. As you can see, this is my next door neighbor. Yes, I'd be irritated, but he's got no reason to believe I wouldn't let my neighbor borrow my car or my husband. And he can inquire to a certain extent, certainly. And we're not saying he can't inquire, but what I am saying is that you can't then, once your inquiries have your fears of stolen car have been allayed, that you can then still just presume that this registration, that if your name's on the registration, it's unauthorized, the car is stolen.
So let's, in Henley, which is not exactly on point, but it's about 3 people in a car. The driver, it's a rental car. It's in the name of the driver's girlfriend, I guess. And so the driver is arrested, and the other 2 folks have licenses, but the police say, no, you're not authorized to drive this car, therefore we have to impound it. And the appeals court says that's right. They were not authorized to drive the car. Essentially, the police couldn't release the car to them. How does that fit with your analysis?
Well, in Henley, what they did not say was that the driver did not have authority to drive the car, and that they weren't going to call at that early morning hour the owner to see if she would then give authority to yet another party. But they didn't arrest the driver for
No, I understand that, but they said essentially we're not going to allow persons to drive the car that are unauthorized on the rental agreement. And yeah.
Well, no, because the driver was authorized by the person on the rental agreement, and that was not why they were arrested.
No, but
that
then the question was whether the car should be impounded or whether one of the other passengers could drive it away. And the appeals court said no, they were not authorized to drive the car, therefore they couldn't drive it away. So in this case, you've got someone who's stopped, who's not authorized on the papers to drive the car. Can they let him just drive away?
Yes.
Because he indicates this is my mother, right?
Right, because the difference in Henley is that if that driver had just been pulled over for speeding and then did not have a warrant out, that person could have then driven away. What they're saying is we are not going to call the owner to ask if they will give permission to yet another person. But they didn't question whether the defendant, Henley, had permission. That was just accepted.
So is the warrant that was outstanding in this case something we should completely ignore?
Yes.
Okay,
because we don't know when the trooper found out about it. What the trooper testified...
You think it matters?
It definitely matters. Because if he had pulled Mr. Campbell over, given him a citation for failing to stop, and then at that point in time when he was done with that did not know that there was a default warrant out, he would not have arrested him on it. And even
if he then went back to his cruiser and said, oh my God, there's a default warrant, could he then have stopped him again and taken him out of the car?
I don't know. It was for failure to appear for jury duty, and the maximum penalty for that is a fine.
But it's an arrest warrant, right?
Yeah, I believe they probably could have.
Could have stopped him and arrested him.
But they didn't, and the law is that it has to be virtually certain that he would have done so. And so the facts of this case are that at some point in time, according to the trooper, he found out that there was this default warrant. We don't know when it was, but we know that it could have been after he'd already searched the car and then put him under arrest. And it could have been beforehand, and he's explicitly decided not to arrest him on it.
What does the transcript say? We have no findings from the judge on this. But what does the transcript say? What does the trooper say?
The trooper says, and I believe this is on page 21, at some point in time, I think the question is, at some point in time, you found out there was a default warrant. Yes.
That's it.
And then the second trooper, so the second trooper appears on the scene after he's already started inventorying the car. After the defendant is then arrested, the trooper then tells Mr. Campbell that he has a default warrant. But where that happened, and the Commonwealth has the burden to prove that.
We know that the second officer was called only after the arrest was made, correct?
I don't remember that. I remember that it was the second officer's called in while he's inventorying the car because he doesn't want to be there by himself, but
But it was after the inventory had begun.
yes. Yeah.
So, and the inventory was premised on the arrest.
Well, he wasn't arrested for use without authority. He was just placed in the back seat of the
Yeah,
cruiser.
what does that mean?
That means he's just sitting there, not under arrest.
Well, but they weren't, basically it means that the trooper was not going to let him drive the car because he wasn't on the rental agreement.
The officer said he put him there for the officer's safety. What I think that means is he's not going to let him stand there while he searches the car.
But,
I
but
mean,
there
of
wouldn't
course-
be any reason to search the car if he was going to let him drive away, right?
Right, he was absolutely going to impound the car.
Yeah, that's all I mean. I mean, that,
Yes.
so,
Absolutely, he was going to impound the car.
Well, let's assume you are right, that it's not a crime of use without authority, but it is a contractual breach. May the officer say, you're not allowed to drive this car pursuant to this contract, but I'm gonna give you a ticket and let you drive away?
That's what should happen, because the officers aren't in charge of determining what's appropriate under a contract. They're not in charge with enforcing contracts.
what would
They're-
the ticket be for?
Failing to stop at the stop sign.
Oh, I'm sorry, yeah, okay.
But
And-
so it's not their role. It's not their job. There's lots of things that aren't fair in this universe that they do not get to arrest people for or stop people from doing.
So what is the legal distinction between the kid who sees the keys in the car and drives it away on a joyride without authority versus the person who is a relative or a friend who drives it without authority?
Without the renter car,
Without the
their name on the
owners, without
contract.
the owner, or in this case, the renter's authority. I mean, or the example you gave, you allow your husband to drive the car and he allows a friend, and you never allowed the friend to do it. All that they know is this other guy who does not appear to be related to you, is driving your car. How are they to distinguish between this guy and the joyrider?
I think what they get to do is they get to inquire, right? If you have a reasonable suspicion that something's going on there, you get to ask about it. Well, who's this car? How did you get permission to drive this car? All of that stuff, and then
And so the joyrider says the car is owned by it's the mom of a friend of mine, and I'm allowed to. And the police officer says, okay.
But there'd be more, I mean, the registration, he'd have to find the registration and see what the name is, and, I mean,
right, he'd have to be good at lying, and he'd have to also not be doing other things. If you're nervous about it, they get to prolong that stop. If you're, if it's being, if you don't pull over immediately, if you don't have a license, if you can't find the registration, there are a lot of things out there. And, if you still have questions and you want to call the owner, there's nothing to necessarily stop you from doing that, but you need to have a reason.
Let me ask you here, was there a match between the defendant's last name and his mother's last name?
No, his mother's last name is Gillard.
But there's no indication that the officer didn't believe him that this was his mother, right? I mean, that's not a factual issue here.
No, it's not, because the officer said, you're not on the agreement, therefore you have committed use without authority, which means you can't drive the car.
You're,
But you said you didn't place him under arrest for that.
He did not.
Right, you just said you're not authorized to drive this car, sit in the back of my car.
Right.
so, you do make the argument also, right, that separately, that given where this was, Heath Street, July afternoon, 4 o'clock, even if there was, even if he's not in the rental agreement and the officer could say, you can't drive this car, he should have left it there.
Yes.
He should have left it for the mother to come get.
What
Right.
he should have done is he could have done either of two things. One is he could have asked Mr. Campbell for a reasonable alternative resolution, and if he said, you know what, it's fine with me, we'll just park it here, that should have been it. Or if they felt like that wasn't enough, they could have called the mother and asked her for the alternative reasonable. But under these circumstances, it was absolutely not reasonable to do so because he's legally parked on the side of the road. It's 4:30 in the afternoon. It's summer, so you've got many hours left of daylight. And I can tell you that I would have been livid if I had lent my car to my husband, and for some reason he got arrested. And in addition to then somehow having to get my husband out of jail, I had to pay impound fees and towing fees and had to find where the impound lot was when the officer could have just called me up and had it be parked on the side of the road and I could have come and got it. I mean, maybe I would have said, you know what, impound that, I'm never going to make it there. But maybe I wouldn't want to go through all that hassle. We say it's okay for a defendant to have to wait 20 minutes for a drug-sniffing dog to come. I don't think it's world's biggest deal to ask the police to spend 10 minutes to call someone to ask.
And assumes they can reach you.
Right, but at least they made an effort, right? I understand, I'm not livid if they've called and I haven't answered. And that's not, what's unreasonable is not even trying. I mean, if you try, no one thinks that they should have to try if they're gonna have to sit on the side of the highway or if it's 2:30 in the morning. But if the question is, hey, can I just quick make this phone call because this driver knows who this person is and put it on the side of and leave it in an already legally parked lot, where it's not dangerous, where it's not blocking traffic, and that seems like the reasonable course of action in this particular case and in cases that are like this case.
Okay, thank you.
Thank you, Your Honors.